Good morning, members, and welcome to today's licensing board for the Wigtown area. And just a wee note, this meeting is being recorded and live streamed. Can I remind remote participants to follow the good practice guidance, which includes muting microphones, switching off your video when you're not addressing the meeting, writing speak in the Teams chat function when you want to contribute. Please don't repeat any contributions already made by our members. No material should be posted in the chat function if it is intended as part of the discussion. If any member has to leave the meeting, please enter leave in team chat meeting for that period of time or write leave in the Teams chat function. All members should speak clearly and directly into the microphone when making contributions. When referring to reports, please provide reference to the relevant page or paragraph to allow everyone to follow. Please focus contributions on areas where clarification is required or to purpose an alternative to a recommendation. Now, folks, let's move on to the agenda. And can we go to item number 1, which is the sediment and apologies?
Thank you, Convener. We have apologies, Councillor Hagman. We're quorate with 5 members out of 6 attending this morning, yourselves in your capacity as Convener. Councillor Dashver, Councillor Hill, Councillor Ingalls and Councillor McCammon are present here remotely. Thank you.
Terrific. And I would like to give approval of remote participation. And moving on to item number 2, does anyone have any declarations of interest?
None, Convener.
I'm not seeing any hands, not a problem. And if we move on to item 3, minutes of the meeting 20th of January 2022, and therefore approval. Councillor Ingalls?
Yeah, a note that I think I was the only one in attendance at that meeting.
That's right.
Mm-hmm.
Yeah, so I'm happy to approve. I don't know whether it needs a seconder.
Do we have any advice from the officers on this matter?
Hi there, Convener. Sorry, Aideen.
I was just going to say, Sharon said if David was happy to approve
Yes,
in Katie's
that's-
absence, that's
yeah.
fine.
That's what I was just going to say. Thank you, Convener. Yes, Councillor Ingalls can approve by himself this item. Thank you.
Not a problem. So
Approved.
those minutes are approved by David Ingalls. Item number 4, meeting of the 22nd of June 2022, and therefore approval. Councillor Ingalls?
Yeah, I'll approve that.
And do we have a seconder? I'll second.
I'll second.
And on to our next item of business, item number 5, Licensing Scotland Act 2005, applications for occasional licences and extended hours granted under delegated authority, report by the clerk to the board.
Convener, this item is just for noting. Thank you.
Not a problem. And do the members have any questions?
Nope, noted.
Noted. And that's us noted. Agreed to note. Item number 6, Licensing Scotland Act 2005, applications for minor variations granted on a delegated authority, report by the clerk to the board.
Convener,
Noted.
again, this item is just for noting. Thanks.
Not a problem. And no questions? Noted. Excellent. Item number 7, Licensing Scotland Act 2005, applications for transfer of premises licences granted under delegated authority, report by the clerk to the board. And that'll be again for noting. Do any of the members have any questions on that? No.
Noted again. Yeah.
Item number 8, Licensing Scotland Act 2005, surrender of premises licence, report by the clerk to the board. And I believe this is for noting again.
Yep, noted.
And no questions. Noted. Item number 9, Licensing Scotland Act 2005, application for variation of premises licence, Bridge Arms, Strand, report by the clerk to the board.
Thank you, Convener. Can I just check from the outset, do we have anybody present remotely this morning to speak to this application? I do understand that Mr Garrett is available by phone. That is what he's informed us of. I'm not sure that he's actually present at this moment in time, but I will just check. Mr Garrett, can you hear me? Are you present?
No, he's not, Caroline. He's on the Stena ship working, but he said if the members have any queries, he'll have his phone on standby.
Okay, thank you for that clarification, Aideen. So members, this is an application for a major variation in respect of the Bridge Arms. The premises licence holder is Garrett Organic Limited, of which Mr David Garrett is the sole director of this company. And as you've just heard from our senior licensing officer there, Mr Garrett has advised that if you do have any questions, that you can certainly attempt to make contact with him this morning. Just as a preliminary note, members, I do have to raise, you're fully aware that the applicant is obliged to display the site notice in a place and at a height where it can conveniently be read by members of the public for a full continuous 21-day period, advertising that notice of the application has been made. In this instance, the site notice was displayed from the 11th of August to the 1st of September 2022. If you note at para 2.4 of the report, the LSO has advised that she routinely visited the premises on the 17th of August 2022, being 6 days after the site notice was up. And it was not displayed in the correct location. She's advised it was displayed inside the entrance door and within the premises. So as a preliminary point, you do retain the legal power. If for any reason you're not satisfied that it's been displayed for the full 21-day period, in a place and height where it conveniently be read by members of the public, and we do refer in our letter to applicants that we do suggest that they display the site notice within that forward-facing window so that all members of the public can see. You do retain the legal power to require redisplay for a further 21-day period. Mr Garrett is obviously not with us at this moment in time. As I say, there was a 6-day display period. It was displayed, but it was not displayed in the correct location. So as a preliminary point, members, do you wish to just continue hearing this and considering this application? Do you wish Mr Garrett to redisplay the site notice for a further 21-day period? Obviously, if that did occur, this would set his application back possibly for a period of time. Or alternatively, you could also try and make contact with Mr Garrett and ask him the reasons why it was not displayed correctly for that 6-day period. So there are 3 options here. Thank you.
And I would like to invite any members in for comment. Councillor Ingalls.
Yeah, I think given the fact that the notice was up within inside the premises and all his customers could see it, he's probably felt that was enough. Perhaps he's not read the detailed instructions properly, but I don't really see that that's a reason to withhold this, convener.
Thank you, Councillor Ingalls. Councillor McCann.
Yeah, I would agree with Councillor Ingalls. However, it may be it may be worth trying to get a hold of him, and I don't think it's grounds to refuse it. But just to make him aware of, that he hasn't adhered to the rules, if you like. But I would like to try and get a hold of him just to ask him why. But I think, as Councillor Ingalls has said, he's probably thought, let's put it up in the shop, and it's enough for the customers to see. But maybe just try and give him a ring.
Thanks for that, Councillor McCarman. I know from my knowledge of the Bridge Arms and the statement in the report that the notice was on the front door area. It is like a small porch, which I imagine isn't visible to the full public unless you were going to go in, but he perhaps thought that was suitable. But that's for him to give us that detail. All right, would any other members like the applicant to join the meeting and be contacted? Councillor Ingalls, is that a hand or is that a legacy hand?
It's a legacy hand, but I will come in. I mean, I'm quite happy to see if we can get a hold of the guys and ask him the question. Yeah.
Not a problem, members. I think we've got an agreement there to get a
Convener,
to.
can I just clarify? If we can't get hold of him, that's not an objection from me.
Right, okay. Well, what we'll do then is we'll take an adjournment for 10 minutes and try and contact the applicant, and we'll re-adjourn in 10 minutes at 10:50. Is that all right with the officers?
Aidan, are you able to attempt to make
that's
contact
fine.
with Mr. Garrett as requested by members?
Yes, I can just dial him now if you like.
Well, if we dial him now, and if he comes straight in, we'll just keep the meeting going, and if we don't get him, we'll adjourn for 10 minutes.
Okay.
Will we say that?
Right, I'll just dial him on my mobile. Hello, David. It's Aidan Sloan calling from the licensing board meeting at the council. Can you hear me? Call failed. He was disconnected. So
Did he attempt to? Did he answer the call, Aidan?
yeah, he answered sort of faintly, and then it seemed to be the.
But well, I would suggest if he's not in a place where he's got good signal, then we'll reconvene at 10:50 and give him some time to get into a place where he's able to take the call.
Okay, I'll
No
keep trying him. Right.
No problem.
Aye, convener.
I will, Ru. That's right. Hi, members, and now we can reconvene at 10:50. Aidan, were you able to get hold of the applicant?
Still on the holding screen, Andrew.
Are we also on the holding screen?
David Garrett
is now joining.
Excellent. Hi, David, can you hear us clearly?
Yes, I can hear you. Thank you.
Excellent, excellent. So I think I'll pass over. I'm Andrew, the chair of the meeting of the Westminster Licensing Board. I think I'll pass us over to Caroline Trainer to introduce. And
okay.
Thank you, convener. Can you just identify yourself? Are you Mr. David Garrett, the sole director of Garrett Organic Limited, the applicant in relation to this application? Good morning, Mr. Garrett. Beg your pardon. I've just put my camera on. Good morning. My name is Caroline Trainer. I'm solicitor to the Licensing Board. Members have a question for you.
Caroline.
Yes.
I'm sorry. Can you say that again, Nadine?
Sorry, Caroline, I didn't quite get that.
Yeah.
Caroline,
can you hear?
Caroline, are you on mute?
No, I'm not on mute.
I can hear you, Caroline.
I can hear Caroline.
Yeah. So members can hear me this morning. Aidan
Yes.
Sloan, our senior licensing officer, you cannot hear me. Mr. David Garrett, can you hear me clearly?
I can hear you, yes.
Thank you. Okay, so Mr. Garrett, just to explain, in terms of the law, you'll be aware that you're obliged to display a site notice at or near the premises in a place where it can conveniently be read by members of the public. The reason you know that for a continuous 21-day period is because you're advised that in a letter from the licensing team.
Yes.
It is the case that you were obliged to display that site notice from the 11th of August to the 1st of September 2022. Yes. You'll be aware that a licensing standards officer routinely visited your premises on the 17th of August 2022, being 6 days after the first date of commencement of display, and instead of the notice being displayed in the front-facing window, which you're advised to do to meet statutory requirements, it was inside the entrance door within the premises, and the LSO requested that you move it to a place where members of the public can see it conveniently, which would have been in the front side of the window. So the issue here is that the site notice was not displayed in accordance with the law. So the licensing board do retain the legal power to insist that you redisplay your site notice for another 21-day period, or alternatively, they don't need to make you do that. So I guess without putting words in our elected members' mouths, they would just like to know why for 6 days, the first 6 days of that display, the site notice was not displayed in the window for members of the public to see, which is very important for public engagement, and it was displayed inside the entrance door of your premises. Thank you.
Yeah, that was a mistake, Caroline, a mistake on my part. I must apologise for that. I thought that when the property was open for business, the site notice was displayed so that anyone approaching the property could see it. But as I'm aware now that it had to be on the window, I moved it at Julia's request there, so I must apologise for that.
Thank you, Mr. Garrett, for giving us that information and confirming that it was an oversight. Members, do you have any questions, or are you content?
Convener, can I come in?
Councillor Ingalls?
Yeah, I'm quite happy with that. I think we should. I would be happy to propose that we grant this application.
And do you have a seconder?
Yeah, I'm happy to second that.
Yeah, no, that's fine. I'm happy and satisfied with that response.
But thank you, members, and can we remember that we've got the hand function? Thank you very much, Mr. Garrett.
Yep. Just like to apologise for my non-attendance to the board.
No, not a problem. I'll hand you over to Caroline Traynor for a final.
Lovely, thank you.
Okay, thank you, convener. So, Mr. Garrett, the licensing board has just granted your application in its entirety, and you will be notified of that decision in due course in writing with your revised licence to you in early course. Thank you.
Excellent. Thank you very much for your time.
Thank you, Mr. Garrett. And members, moving on to, let me just find my place in my part again. Moving on to item number 10, application for variation of premises licence, Regis Bar and Function Suite, Strand. Report by the clerk to the board.
Thank you, convener. I believe that we have Mr. David Ryan attending by telephone this morning. Mr. David Ryan, can you confirm your attendance, please, and also that you can hear me loud and clear?
Yeah, I can hear you. Yes, I'm in the attendance. Yeah, how you doing, folks? You all right?
Thank you. So I'm just going to read through the report, convener. So this is an application for a major variation in respect of Regis Bar and Function Suite at Dalrymple Street in Stranraer. Again, as a preliminary point, convener, I must raise the issue with regard to the erroneous display of the site notice. We've just gone over it. Is the applicant is obliged to display it for a full continuous period of 21 days at or near the premises and in a place which it can be conveniently read by members of the public. The display notice dates were the 5th of September to the 27th of September 2022, and the LSO visited the premises on the 6th of September, being 1 day after it was displayed, and this site notice was displayed inside the premises. And following a request to do so from the LSO, the applicant was asked to move it to a prominent position in front of the premises, which I understand was actioned. So as a preliminary point, convener, you do retain the legal power to require redisplay of the site notice for the full 21-day continuous period, in which case the application would be put back to another date for another hearing, or alternatively you just may wish to hear from Mr. Ryan the reason why for the first day he did not display the site notice in accordance with the statutory requirements. Thank you.
Thank you, Caroline. I'll open up to the members. Do the members have any questions for the officers at this point?
No.
No, I'm not seeing any. No. Mr. Ryan, would you like to give us a presentation from yourself, or go through?
Yeah, no problem. It was pretty much the same as Mr. Garrett, to be honest with you. I had it displayed just on the in our door in a glass cabinet next to my personal licence. I thought it was as long as it was displayed during public hours. I misread the email. I didn't realise I had to go on the outside of the building, but luckily enough it was only like the 1 day, and Julia came straight in as soon as she told me. We laminated a new copy up straight away and stapled it on both outer doors for the remainder of the period. So for that day it wasn't up. I apologise, and as soon as Julia said it, we took action and rectified the situation immediately. Hope that's a good enough explanation for the board. We've complied in every other way.
Thank you very much, Mr. Ryan. Do any of the members have any comments or?
Nothing from me.
Nothing from yourself?
No, all good, thanks.
Well, members, if we go into, I'm going to use planning terms, if we go into session.
Convener, beg your pardon. So so the preliminary point to address is whether you're happy to proceed with consideration of the application, notwithstanding that the display of the site notice met statutory requirements. If you agree to proceed, then if I may, I can go through the report for you.
All right, no problem. Are members happy to proceed? Councillor Hill?
Yeah, happy to proceed.
Thank you, convener. Thank you, members. So this is an application, members, for a major variation in respect of Regis Bar and Function Suite. The application was received on the 17th of July 2022, and it's detailed at Appendix 1 of your report. In terms of the statutory consultation process, I can confirm that that was undertaken by the licensing team. You've just heard that the site notice was displayed for the 21-day continuous period, mirroring the times that we displayed notice of the application on our webpage, the 5th of September to the 27th of September. You've just agreed to continue hearing this application, notwithstanding that there was a 1-day error in relation to the location of the display of the site notice. I can confirm in relation to objections and representations that none have been received. We have the LSO report, which is detailed at Appendix 2 to this application. The police have no adverse comments in relation to the application. So, Convener, just in terms of suggested procedure, you may wish to just hear from the police, the LSO, then if any of you have any questions, then allow the applicant, Mr. Ryan, to speak to the terms of his application, again, which is detailed at Appendix 1 to this report. Thereafter, any questions from yourselves. Thereafter, I would suggest that you allow the applicant to sum up and speak to his application before going into session. And of course, I'm here to give any assistance and guidance if required at the commencement of that session. Thank you.
Thank you, Caroline. I'll open up then to the officers. Would the officers like to give us any presentation?
Thank you, Convener. No, nothing further to add to my report.
Thank you, Mary. And I'd like to open up to the police.
Morning, Convener. No, there was no adverse objections from the police in respect of this application.
Thank you, Caroline. And if that is the case, can we move on to session? Would you like to take us through that process, Caroline?
Sure, Convener. Maybe just before that, Convener, just allow Mr. Ryan to speak to his application. No, not at all. Gosh, not at all. And the terms of which are detailed at Appendix 1 to the report. So if Mr. Ryan can just speak to that application. Thank you.
Mr. Ryan, open to you.
Yep. Yes, what's that, sorry?
To speak to the report.
It's just to Mr. Ryan. It's just to explain to me, Mr. Ryan. It's just
is now exiting.
Mr. Ryan. It's just to explain to members the reason why you're requesting what you are requesting in your application for this major variation this morning. You should have the report.
I don't. I'm sorry. I don't actually have the report in front of me, but I'm taking it regarding the food and the entrance for the 17, 18-year-olds, is it, with at weekends? I'm sorry, I don't have a report in front of me.
Well, it's not a case of having the report in front of you either, Mr. It is your application, Mr. Ryan, so it would be a reasonable assumption that one can assume that you know what you've actually requested the board to grant you.
Yes. Right, well, it's for the food, as I say, we're trying to run a wee kind of family-friendly bar, so we would like to put food on at the weekends, Friday, Saturday, Sunday, through the day, and that's about as far as I'm aware of. That's what I thought the meeting was about today, to be honest.
Convener, would it assist if I just go through what Mr. Ryan has requested the board to consider this morning? Since he's advised, yes, not at all.
So, Mr. I feel really stupid sitting here with no paperwork in front of me at the minute.
Mr. Ryan, so you've requested bar meals be added to the operating plan out with core hours, and you've also requested that the premises open before 11 in the morning for breakfast food. In relation to children and young persons admittance, you've requested that children be accompanied by an adult at all times and young persons be unaccompanied up to 10 p.m. and thereafter accompanied by an adult. And the times you've requested Monday to Saturday 11 in the morning to 10 p.m. and Sunday from 12 noon to 10 p.m. unless attending an organised function or event when they can be present until the terminal hour for the purposes of that function or event only. So it's maybe just your opportunity just to flesh out a wee bit for members this morning, Mr. Ryan, as to the reasons you're requesting this in your application. Thank you.
Basically, the reason I'm requesting it in the application is because there is no licence in place for it, and that's the type of bar that we are trying to aim to be, somewhere where people can bring their kids at the weekend. I mean, I know I'm nearly 40, and if I was to go and watch the football on Saturday, I'd like to be able to take my son in through the day and have a wee toasty and a game of pool and be away up the road. That's basically the reason I need these, and obviously I need these licences in place to be legal to do that. The current licence that's in place was no 18-year-olds at all, regardless, I think, unless there was a function on. That's really the reason for it. And as I say, anybody that's going to be upstairs at the function, it's a private function, but it's really the food license, and so that the guys can come in and have something to eat and have a beer with our kids there too, as long as they'll be at a respectable time.
Thank you for that. Sum up, Mr. Ryan. And Caroline, I'm not trying to jump the gun here, but are we let us be going to session now?
So in terms of procedure, convener, if Mr. Ryan has concluded his presentation and he has no sum up, then yes, you would go into session. You might just wish to check from Mr. Ryan if he's got anything else to add, convener, and then go into session. Thank you.
No problem. Anything else to add, Mr. Ryan?
No, just as I say, that's the type of, we need this variation because that's the type of bar that we're aiming to be. It's a kind of family friendly bar, and food's a major part of it. And as I say, family as well. People have kids of all ages, so it'd be nice to kind of have everybody in. And I don't want to do anything illegal, and I like to keep everyone above board. So I'm hoping the board can grant me that today so that we can move forward. It's obviously going to be a major part of the business, the food side of things, moving forward, especially in the current climate. So apologies to the board for not being as prepared as I normally am today, but that's about as much as I can say on the matter.
Thank you very much. Thank you very much, Mr. Ryan. With that said, we'll move on to session, members. And do we have any comments from the members? Councillor Ingalls?
Yeah, I don't have any questions. The only comment, sorry, hang on a second. The only comment I would make would be one of congratulations for somebody that's trying to build his business and a wee bit of foresight. So no, I don't have any questions.
And any other members? I'm very much in the line of yourself there, Councillor Ingalls. I congratulate forethinking in business, and I take it from you that it was a proposal to grant Mr. Ryan's licence.
Yeah, I think we're out of session, or well, we're in session. Yeah, my proposal would be yes, that we would grant this.
Not a problem. Councillor Hill.
Hi, yeah, I'm happy to second that. I think it's a great idea to have food and, allow families into this venue. So yeah, I'm happy to second that and grant it.
Thanks for that, Councillor Hill. Any other members got any comments or any amendments? No. So Caroline, can I pass it over to you to sum up, please?
Thank you, convener. So just confirming that is a decision to grant the application in its entirety just before I confirm with Mr. Ryan.
It appears to be.
Yes.
The members didn't give us any.
Thank you. Thanks, convener. So, Mr. Ryan, you've just heard from members and your application has been granted in its entirety. You will be notified of the decision in writing in early course, and your amended licence will be out with you in early course. Thank you.
Absolutely fantastic, and again, I can only apologise for not being prepared properly this morning. I'm actually quite embarrassed about that, but thanks for overseeing that, folks, and yep, we'll keep on trying to do our best. Speak to you soon.
Thank you, Mr. Ryan.
Right, thanks, folks. Take care.
Right, members.
I'm okay to leave this meeting now, folks. Sorry.
Yes, Mr. Ryan, you can leave the meeting.
Right, okay. Thank you, folks. Take care. Speak soon.
Thank you. And moving on, members.
Is now exiting.
Oh, that's us. Now, members, on to item 11, Licence in Scotland Act 2005, Review of Personal Licence, Paul Agnew, report by the Clerk to the Board. And to you, Clerk.
Thank you. Thank you, convener. Can I just check that we have Mr. Paul Agnew with us this morning? And also, I understand he has his agent, Solicitor Kenneth Patterson from Rankin and Aitken. Are both gentlemen here this morning and can hear me loud and clear?
Yes, we can hear you loud and clear and we're both present.
Thank you very much. So, members, this is alleged conduct that's inconsistent with the licensing objectives in respect of a current personal licence holder, Mr Paul Agnew. This is under section 84A of the Licensing Scotland Act 2005, brought by the police. On the 6th of June 2022, the Chief Constable, in terms of his power under section 84A, submitted a report advising that Mr Paul Agnew, the holder of personal licence, has acted in a manner that is inconsistent with the licensing objectives of preventing crime and disorder, securing public safety and preventing public nuisance. That report is found at the appendix to this report, members, and of course you'll be aware that we're statutorily obliged to hold a hearing in this case. You recall that a personal licence authorised says a licence holder to supervise and authorise the sale of alcohol. In terms of powers here, member, in terms of the law, just to point out to you that you may, after giving the licence holder concerned and such other persons as you consider appropriate, an opportunity to be heard, and if satisfied that it is necessary to do so for the purposes of any of the licensing objectives, make an order. Now, the options available to you this morning, after hearing from the police and after hearing from Mr Agnew and his agent, are to either revoke the licence, suspend it for a maximum 6-month period, endorse it. You'll recall endorsement is just like a black mark, a bit of a written warning, and it's also open to this morning members to take no further action. You'll also be fully aware in terms of the law that you can reach a decision that Mr Agnew has acted in a manner that is inconsistent with the licensing objectives, but in terms of the law, you're not obliged to make any order. It is a discretionary measure. Furthermore, if you're of the opinion, after hearing all material before you this morning from both the police and also from Mr Agnew and his solicitor, that Mr Agnew is not a fit and proper person to be the holder of a licence, having regard to the licensing objectives, then in terms of law, you would be legally obliged to revoke that licence. So in terms of suggested procedure, convener, I would suggest you hear from the police to speak to their section 84A report. Thereafter, questions from yourselves. Thereafter, allow Mr Patterson to present his case on behalf of his client, Mr Paul Agnew. Thereafter, questions from yourselves. Then allow Police Scotland to sum up their position, and thereafter allow Mr Patterson the opportunity to sum up his position in relation to his client and give him the last say. And thereafter I would suggest that you go into session, and of course I am here to give any guidance and assistance as required, and you may wish to consider whether you wish to have that guidance and assistance from the outset of session. Thank you.
Thank you, Caroline. We'll throw it open then to Police Scotland to give us their presentation then, please.
Thanks, convener. As alluded to by Caroline there, Chief Constable reported under terms of section 84A of the Licensing Scotland Act that Paul Agnew had acted in a manner which was inconsistent with the licensing objectives, which were to prevent crime and disorder, secure public safety and preventing public nuisance. The circumstances which arose to the submission of this report were that Mr Agnew, as the holder of a personal licence issued by Wigtownshire Licensing Board, was due to expire on the 29th of June 2024. At the time of the incident being reported herein, he held the position of designated premises manager as well as the premises licence holder for the commercial inn in Strand. So about 22:30 hours on Saturday the 7th of May 2022, officers routinely attended at the commercial inn to conduct a standard inspection. At this time, they observed a male and female adult leaving the premises, highly agitated and apparent bleeding on the face of the female. Females approached the officers in question to inform them that she had been assaulted by Mr Agnew. Immediately after, Mr Agnew had been involved in an argument with her partner. The female provided further information that the subject had perpetrated the assault by punching her once to the face. A short time later, Mr Agnew was traced by police within the back room of the premises, at which time he was initially reluctant to speak with officers in attendance. On being asked to observe the CCTV footage within the premises, Mr Agnew freely admitted to committing an assault on the female whilst attempting to eject both parties due to their behaviour and level of intoxication. Mr Agnew was arrested in caution and charged with an assault before being released to be reported to the Procurator Fiscal. The female victim was examined at the Galloway Community Hospital, where the extent of her injuries were noted as a small superficial cut to the inside of her mouth. It should be noted that following the very initial reluctance to engage with officers, Mr Agnew was thereafter fully cooperative with the police. Chief Constable's view is that all options open to the board under section 84(7) or 84(7)A of the Licensing Scotland Act 2005 should be considered.
Thank you, Caroline. And do the members have any questions for Caroline Crozier from the police? Councillor Ingalls.
Yeah, hi Caroline, thanks for that. I'm just wondering whether you mentioned this had went to the Procurator Fiscal. I'm just wondering whether this has been determined or what's happening.
Yes, it has been determined. I think I'm okay to say that there was a compensation order given to the victim by the Fiscal's office.
Thank you, Caroline.
Thank you. And Councillor McCallum.
Thanks, Convener. Again, I'm not sure if you're obliged to answer this question, but quite concerning. Does he have similar convictions previously? Are we allowed to have that information? I'm not sure if we are or not.
To be honest, I don't believe that.
Can I just interject there, if I may? Councillor, you can only go before the matters that are before you today. It may be worthwhile when you've just heard from Police Scotland saying a compensation order was given to the alleged victim. You may wish to seek clarification as to whether Mr Agnew has pleaded guilty to this alleged assault or not. That may be a pertinent point for your consideration. Thank you.
Back to Councillor McCallum.
Yeah, so are we able to have that information, Caroline?
I'm not actually able to say whether there was a guilty plea or not, but obviously there was a guilty response in that our finding at court, given the fact that there was a compensation order requested by the Fiscal Service.
Sorry, can I just come back in, Convener? Do you mind?
Yeah, no, that's absolutely fine.
Again, on the night of the incident that's in the report in front of us, was he remorseful?
Obviously, I wasn't in attendance, but going by the information that we received from the officers in attendance, as I've explained, there was an initial reluctance on the part of Mr Agnew to engage with officers, and it's only been at the point of the CCTV request, which was part of the case that went to the Procurator Fiscal Service, that he has admitted to the assault to the officers that were in attendance. I do note, however, that when the letter was compiled, that Mr Agnew was quite supportive of the police inquiry after that point. I'm only going by the information that was provided by the officers at the time.
Okay, I understand. Thank you.
Is that enough information for you, Councillor McCallum?
As much as she's allowed to give, yes.
As much as I'm allowed to give, not a problem. We might find something out later on in the session. Councillor Hill, Councillor Dashborough, have you any questions? Nope. So we'll move on then. Mr Agnew, would you like to give us a presentation, you and your agent? If you would introduce yourselves first, please.
Yes, good morning, councillors. My name is Kenneth Patterson and I'm the solicitor for Mr Agnew, and I'll be speaking on his behalf today. Perhaps I can start off by reassuring Councillor McCammon that I'm more than happy to answer the questions which you raised, so hopefully you'll have full information during the course of my presentation. Basically speaking, I'm not sure whether or not you have details before you as to the actual nature of the personal licence here. Suffice to say that Mr. Agnew is aged 58. He has held a personal licence since, I believe, 2015. Notwithstanding that, he has considerable experience in the licence trade in that in this concerned. He worked there with his then partner, so he has been in the commercial inn for many years. I think I can assure Councillor McCammon in particular that during this period there has been very little, if indeed any, trouble, and this is the first incident which has arisen regarding Mr. Agnew's conduct. So there's been no history of unfortunate incidents within these premises. I would like to think, I'm sure I can say so with confidence, that this is very much a one-off incident. What happened in the night in question was there was in fact a darts domino tournament on in the premises. Mr. Agnew in fact was largely in front of the bar that night. He was supervising things regarding the competition, and sometime during the course of the evening a group of youngsters came into the premises. They just went into the corner and they weren't even attempting to buy any drink, and they just sat there. Mr. Agnew, being an experienced licensee, was not particularly happy with this, and eventually he took it upon himself to say, look guys, I think it's time that you moved on. Obviously I can't produce any evidence as to the state of these individuals, whether they're under influence of drink or drug as the case may be, but subsequent inquiry suggests that they had already been evicted from other premises in the town. And needless to say, as often happens in these places, you can ask people to leave politely, nicely, but inevitably this doesn't happen. Now, sadly, there then has been an altercation. Exactly what happened is perhaps a moot point, but suffice it to say that there was some contact between Mr. Agnew and the girl in question, and Mr. Agnew deeply regrets that. He certainly didn't set out with the intention of promoting any violence. There was just a general skirmish. The area in question within the premises was a very narrow area, and it was inevitable there was going to be a bit of bumping and jostling, and that's exactly what happened. Thereafter, it was purely by coincidence the police were outside. They had no reason to come to the premises. There had been no complaint about anything going on, and it was just one of these things. The police were there, and thereafter they have become involved. I don't think Mr. Agnew had any great pleasure in putting these people out. Obviously, it was disrupting things, and initially, yeah, quite naturally, he was a bit upset. But thereafter, the police quite properly have carried out their inquiries. And I think, as I mentioned, from that point on, Mr. Agnew was cooperative and did everything that was asked of him. Yes, a report was submitted to the Procurator Fiscal, and thereafter, basically speaking, the Procurator Fiscal decided, and I'm not minimising this event in any way at all, but the Procurator Fiscal decided that the appropriate course of action here was to basically offer Mr. Agnew a fixed penalty, which basically speaking means is an opportunity to pay some money, and thereafter the matter is dealt with and there's no need to go to court. My understanding is that this was by way of a compensation payment. Yes, matters of principle come into things, but there are also practical considerations. Did he risk going to court and having a criminal conviction? Was this going to cost him a lot of money? Frankly, Mr. Agnew was, I think, fed up with the whole affair and said, look, I'm just going to pay this compensation and try to move on, and that's what happened. Can I emphasise to the members of the board, and perhaps particularly you to Councillor McCammon, by doing this, no criminal conviction is in fact recorded. So at this point in time, I suppose it could be said very roughly that there is perhaps a act against Mr. Agnew, but as I emphasise to you that there is no criminal conviction. As I've said at the outset, Mr. Agnew has run these premises without any problem for a considerable number of years. He is fully aware of his obligations as a licensee, and he has always done his best to promote the objectives of licences locally in Wigtown. I hope you don't think I'm sounding somewhat flippant, but in terms of the report, licensees have a duty to prevent crime and disorder, to secure public safety, and to prevent public nuisance. Now, bizarre as it may seem, in fact, that's exactly what this man was doing, in the basis that there were people there who potentially were going to cause trouble, and before they were going to cause any trouble, they were to be evicted. Unfortunately, things have gone, dare one say it, pear-shaped, and sadly, Mr. Agnew finds himself in front of the board today. Bearing in mind his excellent record and the fact that there have been no problems in the past, one cannot guarantee, obviously, what will happen in the future, but bearing in mind that his regular clientele are, dare I say it, of the maturer kind, perhaps not involving youngsters, most unlikely that anything untoward would happen. Obviously, I'm fully aware of the powers which you have in terms of paragraph 3.2. I would respectfully suggest that in this particular case, the board take no action. I do this on the basis of hopefully the facts as I've outlined to you. Mr. Agnew has found the last few months quite stressful. He owns the pub. He has sundry part-time staff, one of whom I think has a personal licence. Obviously, it'd be very, very difficult for him to continue in business if the board decided, for example, to revoke his licence, indeed suspend his licence as well. Endorsing the licence, well, that's a possibility, but bearing in mind, I would respectfully suggest on the basis this matter was over in a matter of seconds, really, perhaps the appropriate action here would be to take no further action in the knowledge that Mr. Agnew has appeared before you today. I think it's a salutary lesson for him, and clearly lessons have been learned all round, and I would ask the board to deal with the matter on that basis. Obviously, if you have any further questions, I'll do my best to answer these.
Thank you very much for that information and that presentation. Can I invite Councillor McCalman for questions, please?
Yes, thanks, convener, and thank you very much for the factual statement there, and for addressing my concerns. Two questions, if I may. Why is the applicant, sorry, the defendant, I suppose you could say, Paul Agnew, not here today?
Mr. Agnew. Mr.
Yeah,
Agnew,
oh, hi. All right,
yeah.
all right, so you just chose not to speak. Okay, that's fine. And secondly, let me just look at my notes. So we've had a fair bit of detail from your representative for the evening in question. It doesn't really, the explanation that was given doesn't really address the report, to be honest, and why there was an assault on a female. I understand that you're trying to remove people from the premises, but I'm not too clear on how the reports came about then.
Well, I thought I'd address that, and that basically speaking, there was in essence a skirmish. There's been a bit of jostling in a very confined area, and unfortunately, as a result of that, the female in question has suffered her lip being cut and thereafter bleeding. It wasn't an attempt by Mr. Agnew to assault the person as such. It was just a skirmish in a very confined area.
Okay, that's what I was looking for clarification on. Thank you very much.
Have you got your clarification, Councillor McCalman? Any more questions?
Not at the moment, thanks.
Not a problem, thank you. Caroline.
Thank you, convener. Forgive me. Oh, I put my camera on. Beg your pardon. Yeah, forgive me for just interjecting there. Councillor McCalman has said that Mr. Agnew has chosen not to speak. It was just to set for the record that Mr. Agnew does have a right to be represented today by his agent, and that is the case today. He does have the right to sit with his agent in silence. Thank you.
Okay, I wasn't aware of that, Caroline. Thank you.
Thank you for that, Caroline.
For Councillor McCallan's benefit, Mr. Agnew fully appreciates the gravity of the position. That is exactly why he's here today. As the clerk has correctly pointed out, I'm his voice piece today. I'm not trying to be unduly smart, but having had some experience of peeping into public, I want to make sure that his case is, without sounding big-headed, presented in the best possible way.
Thank you for that. Caroline, your hand's still up. Is that for you to come back, or is...
No, I beg your
Not
pardon.
Alexa.
It's a legacy hand. I'll take down. Thanks, convener.
No, thank you very much. Do any of the other members have any questions?
Nothing from me,
No.
convener.
Nope. Well, without it... Oh, Councillor Hill.
Hi, sorry. Can I just ask, you mentioned in the report that the group of youngsters had been removed from other pubs previously. Was that because they were causing a bit of a disruption? So that's possibly why they ended up in the commercial that evening, because they'd been put out of other premises. And, you know, with you saying that it's normally like older people that go in the pub, not the youngsters, you know, do you think that's possibly why they were in that evening, because they'd been put out of other pubs, possibly, you know, been a bit of a nuisance? Is that what you were getting at in your statement, please?
In fairness to there is a certain element of speculation here. When these people come in to the place, it was not known at that time that they had been evicted from other premises. Inevitably, Stranraer being a small town, jungle drums started to beat, and thereafter it was established that they had apparently been asked to leave premises earlier on. There seems to be a sort of trend in Stranraer amongst younger people. They spend a good part of the evening perhaps drinking at home, and we're doing other things as well, and it's only later on in the evening that they tend to come out. May or may not have happened in other premises, we're not sure about. All we can say is that the strong suggestion is that they were in fact asked to leave because of their conduct.
Lovely, thank you very much. Thank you.
Thank you for that, folks. And is there any other questions? Nope. So with that, I'm going to move on and invite the Police Scotland to sum up, please.
Thanks, convener. Yeah, just to sum up, just to reiterate that whilst I know that Mr. Patterson's saying that it is a minor matter, I would be somewhat concerned that if it was considered a minor matter by the patrons and Mr. Agnew, that had the police not been carrying out a routine check, that this matter would have been overlooked. Obviously, there was a seizure of CCTV that evening. Had that matter not been reported to us immediately by the two victims in this incident, then there would have perhaps been an opportunity missed in terms of evidence recovery from our point of view. Whilst the victim herself has not had a significant injury, it was a sufficient enough blow to knock her to the ground within the premises following that verbal altercation between Mr. Agnew and our partner. It's perhaps more fortunate that she hasn't sustained a more significant injury. So the evidence says that it would be, it could have been much worse. And I am concerned about that loss of evidence recovery had the police not been on site at the time. Obviously, I can't speak to other instances that evening. I would point out that the victim herself is not a particular youngster. She's maybe younger in age and not perhaps the usual age of the patrons of the commercial. She probably stood out as perhaps a little bit younger than the average age there, having knowledge of the commercial myself, but it's she's not a youngster that's sneaked in or anywhere around about the age of 18. She is a number of years older than that. So it would just be for the board to consider the implications of it on this matter. Thank you.
Thank you, Caroline. And could we move on to the applicants? Oh, sorry. Can we have any questions for the sum up, for the police sum up?
Just to intervene there, beg your pardon, convener, in terms of suggested procedure, once the police have summed up their case, I would allow Mr. Agnew's agent, Mr. Patterson, to sum up his client's position prior to going into session. Thank you.
Oh, not a problem. Can we move on to Mr. Patterson and Mr. Agnew, please?
Yes, thank you, convener, members of the board. There's not really that much I would want to add. Please accept from me that I'm not for one moment trying to mitigate the apparent seriousness of the situation which we're addressing today. However, I do stand by my suggestion that this was a minor matter. I do so on the basis that a full report was, of course, submitted to the Procurator Fiscal, and the Procurator Fiscal looked at the paperwork and, basically speaking, yes, there was an element of criminality, but it was dealt with in a very, very minor way. There was an offer of a fixed penalty. There was no, quite often in a question of a fixed penalty, you can, of course, invite the individual to pay a fine. That was not the case. I think it was the most minor of disposals, modest compensation to the complainer here. So yes, in the great scheme of things, yes, any criminal matter and any assault or incident pub is serious, but when you scale it out, it was certainly, in my humble opinion, very much at the lower end of the scale. My position is as outlined, unless the board have any particular questions to ask, I would respectfully suggest, bearing in mind what I've said already, that the appropriate way forward here is to take no further action on the basis of the minor nature, that it was over in literally seconds. There was a stramash which was dealt with fairly quickly, perhaps inappropriately in hindsight, but please also bear in mind Mr. Agnew's record over the years, the many years without any incident. And indeed, there obviously has been no trouble since this matter back in June of this year.
Thank you for that, Mr. Patterson. And now, members, I believe we can go into session. Councillor Ingalls.
If you don't mind, convener, can we take this in private, please?
I'm happy to go into a private session. Would the other members agree?
Yeah.
Yep, agreed.
Yes.
Convener, may I forgive my interjection? Absolutely fine. If I can just explain to Mr. Agnew's agent that you do retain the specific statutory legal power to determine this matter in private, if that is what course you decide to take.
Mm-hmm. It seems
certainly
like
not unusual matter insofar as I'm concerned, but quite often the board have gone into private session to consider things, and I quite understand that.
But thank you, Mr. Parson, for understanding that we'd like to take legal advice in private. So, members, can we go into a private session and adjourn the current board, please?
Aidan, are you able to facilitate that at all, please? That Aidan Sloan, our Senior Licensing Officer, and maybe our technical expert.
Yeah,
breakout room.
I'll breakout room. I'll just send a new meeting invite, I think so.
Does that come into an email box? Just an email inbox, Aidan, the new meeting invite?
Yeah, yes, into the calendars. And that now.
Oh.
Yes.
Yes, members can just click on the link for this one to rejoin. So if we leave the current meeting, and I'll send a new invite just now.
Thank you, Sandy.
Okay, thanks.
Thank you very much, Andy. And that's us back members from our private session. We've all had advice from Caroline, and I would like to hand over to Caroline now to give the procedure.
Thank you, convener. So it was just in terms of complete transparency here, just to go over the more salient points that were discussed, and obviously any decision is made by elected members of the board today and certainly not by officers. What we discussed was the need for the best evidence rule. Essentially, the board is clearly a quasi-judicial body, and any decision making must be evidence-based. It must have a proper factual evidence base to decision making. Discussion that there was no CCTV presented by the police, although there was comment that it was seized. And just questioning why there was no CCTV put before the board today to support the version of events by the police, or alternatively any written signed statements by attending police officers were not submitted, being aware that the representation was given by Sergeant Crozet, who was not an attending police officer. It was also, members could discuss that there seemed to be a conflicting version of events. On the one hand, Police Scotland saying that Mr Agnew admitted an assault to a customer within the licensed premises, and then on the other hand, Mr Patterson, Mr Agnew's agent, advising that it was the context, it was jostling a female, had suffered a cut to her lip, but there was an attempt by Mr Agnew to actually stop any trouble by being caused. It was within a confined space and he was trying to eject individuals. So it was noted that there was a conflicting version of events there, and that there was no CCTV evidence before members to actually see that best evidence. What was discussed as well was that the first stage in the process was for members to determine whether Mr Agnew has acted in a manner that is inconsistent with the licensing objectives. That's the first step in law. Based on the material before them from the police and from Mr Agnew's agent, has Mr Agnew acted in a manner that was inconsistent with the licensing objectives? If so, which licensing objectives is it? Is it or are they? And of course, discussion that the licensing objectives are not freestanding public interest objectives. They're preceded by the word licensing, which means they are relevant to the sale of alcohol. And it is noted that this alleged incident has taken place within licensed premises where the sale of alcohol has occurred. And then it was discussed that if it's the case that members are of the mind, based on all the information before them and balancing all material considerations, that Mr Agnew has acted in a manner that's inconsistent with the licensing objectives and which relevant licensing objective, then the stage 2 is it must be necessary in law to make an order. One can make a determination that a licence holder has acted in a manner that's inconsistent with the licence objective and still not make an order, because it's a discretionary measure. So if the board deem it necessary to make an order, then they're required to explain why it's necessary to make an order. And then there was discussion of course, the different types of orders that can be made. The revocation, whereby the licence is dead, it's gone. The suspension up to a maximum 6-month period. Endorsement of the licence, which is a bit like a written warning come black mark, or indeed no further action. And these were the more salient points that were discussed. It was also, I also drew to the board's attention the need for them to exercise their discretion in a reasonable manner. They must be reasonable in all of the circumstances, and any step that they take must be proportionate. So that was just in terms of transparency and clarity there, convener. So I'll stop talking and I will hand over to you as elected members of the board to deliberate and make a decision. Thank you.
Thank you, Caroline. And I would like to open it up to the members. Do we have anyone who would like to come in? Councillor Ingalls?
Yes, I'll come in. Thanks, convener. Yeah, I think this one's it's a bit difficult, this one. I think my own view on this is the this whole incident could have been dealt with better. I think probably this, had it been dealt with better, then it would not have come onto our agenda today. And I think the licensee has a responsibility to avoid this situation. I think given what happened within the premises and the 3 license objectives that have been highlighted by the police are probably fair to me. You know, I think personally, I just think it could have been dealt with better. And my view on this would be we'll be asking the recommendations for a decision on 3 ways that we can deal with this. And my own personal view is an endorsement would be the way I would like to see this dealt with. Thanks, Convener.
Thank you, Councillor Ingalls. Councillor Hill?
I've looked at all of the evidence, and my personal view is that the Procurator de Fisco has dealt with this issue. I would imagine that he's had or she's had the CCT to look over in due course, and I feel that we haven't got that evidence in front of us this morning, so we can't look it over. It's not for us to punish Mr. Agnew. I think that, looking back and hearing from the solicitor that nothing like this has happened before or since, that possibly, like David Ingalls, it could have been dealt with a bit better. But if it isn't a situation that's arose before, then maybe that's why it did turn into a bit of a tussle. And I feel that possibly if the police hadn't been at the doorway on the premises, then the police might not have, it might not have been reported. The people would have just left the premises and it would have been left. In my view, I'm happy not to bring any further action forward, but I would like to say to Mr. Agnew, it'd be a learning curve, and if a situation did arise in the pub again, maybe speak to staff, and if you're going to ask somebody to leave, make sure a member of staff is there too. If they're not leaving, possibly phone the police in that instance. But that would be my view today. Thank you.
Thank you, Councillor Hill. Councillor McCallum?
Yeah, thanks, Convener, and thanks for being so patient with us. Yeah, I don't really have much more to add. I'm in line with Councillor Ingalls. I'm afraid I just feel that there could have been more calmer conduct. There's too much conflicting information in here. Whilst we don't have the evidence, enough evidence, if you like, for me to reach a firm conclusion, we also don't have enough evidence for the opposite. So based on that, I'm going to go for endorsement as well.
Thank you, Councillor McCallum. Oh, and I believe, Councillor Hill, you've got a legacy hand up, is that? Councillor Hill?
Sorry, Andrew, I lost connection there.
Oh, sorry, yeah. Your hand is up as...
Oh, sorry, no, I'll take that down. Sorry, no.
Not a problem.
My
Councillor Ingalls?
apologies.
Sorry, yeah, I'll come back in. I'll make that formal proposal that at 4.1 of the recommendations that we endorse the licence.
Councillor McCarman, I believe you were willing to second that.
Sorry, Andrew, can you repeat that? I missed that. Sorry, my connection's just gone funny. Could you repeat that? Sorry.
Did you miss David's bit? Sorry.
No, I got David's first bit and then I spoke and then I lost connection for the volume. Sorry, could you repeat?
Well, Councillor Ingalls has put on a proposal and we have a motion to endorse the licence. And I'm inviting Councillor McCarman to second that.
Yeah, I second it, Convener.
You second that. And Councillor Hill, do you have an alternative, I believe?
Yeah, sorry, my alternative would be to speak firmly to Mr. Agnew and take no further action.
Thank you, Councillor Hill, for giving us that. Well, it comes down to me, Councillor, and I'm on the side of Councillor Hill here, and I would like to second Councillor Hill. I believe it's for the police to bring us sufficient evidence to prove that the licensing objectives haven't been followed here. I see that the only proof that we've had here is that the Procurator Fiscal has given in a sense, a slap on the wrists. And without that camera evidence, which for me would be for the police to give us to make this decision, I don't feel like that we can do anything. And I would suggest that we take no further action. Caroline, I'm seeing that Miss Crozier has put her hand up. Can Miss Crozier interject at this point in the meeting?
No, unfortunately not, Convener.
Unfortunately not.
In terms of procedure, if I just just to say, so we have a motion from Councillor Ingalls to move to endorse the licence. This is seconded by Councillor McCammon. There's an amendment for Councillor Hill, from Councillor Hill, beg your pardon, that no further action be taken. And this is seconded by yourself, Convener, that no further action be taken. So we have an equality of votes 2 by 2. And in terms of procedure, as you are the convener, you have the casting vote. So which decision is it to confirm, please?
I will continue with my first vote.
So that no further action is taken. And that is, you've just said it's because there's no evidence submitted before yourselves today.
I don't feel there's enough evidence for us to take this forward, and it's for the police to bring this evidence to us for this hearing, and it's for the defendant to defend on that evidence, not give us evidence of why they should not be at the hearing.
Okay. Convener,
Councillor Hill, sorry.
Yeah,
if you want to comment on my back.
I mean, no further action, but we do need to highlight, that it was severe. Somebody did get injured, and I am aware of that. But I do feel that Mr. Agnew in this case, will have suffered stress from the incident, stress from the waiting, the unknown, and I feel that the Procurator Fiscal has dealt with it. So that's what I wanted to say. Thank you.
Thank you, Councillor.
Okay. Convener, shall I just read the decision to Mr. Agnew's agent?
Yes, please.
Okay, so Mr. Patterson, you've heard the board members discuss this matter. A motion was made by Councillor Inglis to move to endorse the personal licence, and this was seconded by Councillor McCammon. An amendment was made that no further action be taken, and this was seconded by the convener. So we have 2 against 2. And the convener, in terms of the Licence in Scotland Act 2005, does have a casting vote where there's an equality of votes, and he has cast his vote for the amendment that no further action be taken in this instance due to concerns with lack of evidence. So the decision is to take no further action in relation to this matter. Thank you.
Thank you,
and
Caroline.
just to advise, in relation under the Licence in Scotland Act 2005, the police do not have any right of appeal under that regime, but of course they may wish to take their own legal advice with regard to anything else if they wish to pursue the matter further. Thank you.
Thank you, Caroline. And members, I believe that is us come to an end of today's meeting. There's no other business. And our next meeting date is Friday, the 16th of December, 2022. And I would like to wish everyone to have a good day. Thank you very much.